Hello, thank you for joining me. Just get a couple things set up here and we will get started with estate planning questions and answers for today. So if you have any estate planning questions, what is a will, what is a trust, what is probate, please put your questions in the comments and I will try to get to those. I do have some questions that were emailed to me, so I'm going to be going through those. If you can hear me, can you please give me a heart or a thumbs up so that I know that the sound quality is okay and that you can hear me? That would be awesome. And let's get to our first question, just making sure. Thanks, Deanna, appreciate that. Okay, so first question. For those of you who don't know me, my name is Crista Hermance. I'm an estate planning attorney. I come in here every Wednesday at 6 p.m. to answer your questions relating to estate planning. So a lot of people don't know what estate planning attorneys are and what we do. So dealing with anything related is, and if you're just joining us, make sure to post your comments, post your questions in the comment section, and I will try to get to those. Okay, so before I get to the first question, I wanted to just give a really quick story of something that happened this week with a case that I have. And I think it's very impactful, and that's why I am trying to shout it from the rooftops, because I think people just don't understand this. So I had a client that came to me after her mother and stepfather passed away. And her mother and stepfather didn't have any planning documentation at all. They didn't have a will, they didn't have a trust. And both her mother and stepfather had passed away within the last year. So she came to me because they owned a house and they owned it as joint tenants. A lot of times when you buy a house, you don't really get any direction on how to own the property. And so it's, you trying to figure out how to take ownership of that property, especially if you own it with somebody else. So her parents, or her mother and her stepfather, and it's like her dad because they had been married for 25 years and he had pretty much raised her. So her parents, I will say for all intents and purposes, own the home as joint tenants. So after they had passed away, she came to me trying to get help. And so we are going to have to start a probate proceeding because they owned it as joint tenants. And because they had both passed away and had no planning documents, the house was going to have to go through probate to be able to get to her as the only child. So in our discussions and after going through a few of the details and trying to figure out, everything that we needed to do for probate, it came up the order of how the parents passed away. And the reason for this is because the property was held as joint tenants. So what happened, and again, this didn't come up until we were kind of hashing through everything to file the petition for her probate, was that her mom passed away first, and then her stepdad passed away, let's say 6 months after. Well, because of the order of how they passed away, and because the property was held as joint tenants, once her mom passed away, that property went to her stepdad completely as his. So it's with right of survivorship. So it all went to him. And then once he passed away, it then goes to his heirs because he has no will, he has no planning documents. And so our client isn't his heir. It's actually his estranged daughter that he hasn't spoken to in like 25 years. And so my client, who is living in this home, her parents' home, it's not even her house because they didn't have the proper planning documents. They didn't have the proper documentation that would say that if something happened to them, they would want her to get this house. And so now, because she is not the heir of her stepdad, this house is going to go to his estranged daughter. And that is probably not what the parents would have wanted, right? But if you don't take these things into consideration, and I tell you, go look at how you have documents list how you have property listed. How is it vested? Or your parents, right? This comes up especially a lot with older people. How are they holding title so that you know? And that if it's not the way that they would want it, get it changed. Get those planning documents in place. That's why it's so important. So I just want to share that story because I think it was very impactful for people. Just, things happen when it's not what your intention is, but because you don't understand how things work. And at this point, she isn't getting any of her mom's house. And this was originally her mom's house, and she added her stepdad to title. So she's not getting any of her mom's property because stepdad was listed as a joint tenant. And because her mom passed away first, everything went to the stepdad. And not that stepdad would not want her to get it. It's going to his daughter because she is the rightful beneficiary and the rightful heir of his stuff. Okay. Okay. So if you have any comments, again, please post if you have any questions, please post those in the comments and I will get to those. And so I'm going to go to the first question that was emailed to me. Okay, so I have a daughter that graduated from high school recently and she's going away to college. Do I need to do any legal documents for her before she goes? This is a great question, and congratulations on your daughter graduating from high school. I know that this year has been quite a different story when it comes to graduations, but there absolutely is legal documents that you can put in place for your daughter to make sure that you're being informed, that you're being involved if that's what she wants. So the first thing I will preface by saying is that when you have a child, your own child that turns 18, they are a legal adult, which means that they can legally make decisions for themselves, which also means that you as their parent can no longer make legal decisions for them because they are an adult. And I think that's really important to understand because a lot of times parents think that, well, they're my child or they're on my health insurance, that, I can continue making decisions for them or I have a say of what's going on. But once they turn 18, you lose that right. Even if they're on your health insurance, you can't necessarily know what's going on from a health perspective, call their doctors, find out information because it's protected. There are HIPAA laws. So some of the documents that are really important are, the first one is a power of attorney document. So this is a document where you or your daughter as the agent can identify an agent to make financial decisions on her behalf if she is unable to do so. And the reason this document is so important, especially for a young adult that's going away to college, is maybe they still want you to be involved in their life, to be able to go to the bank for them or pay their credit card bills and have that kind of ability to do things for them. Just because they're going away to school, they still want you involved. And so that's why the power of attorney is a really important document. The next document is an advanced healthcare directive. So one thing I will say is that I am licensed to practice in California. So all of the stuff that I'm going to be going through is what's in place in California. So if you're outside of California, it's important to make sure that you work with an estate planning attorney in your area to understand what documents are required. So in California, we have an advanced healthcare directive. And this is a document where you identify agents to be able to make healthcare decisions for you if you are unable to do so. And so for your daughter going away to college, an advanced healthcare directive would allow her the ability to put you down as an agent. And for you, that if something happened to her, like if she was out of state, you have this document that says to doctors, if something were to happen to her, yes, I can make decisions for her. I can know what's going on. In addition to the advanced healthcare directive is a HIPAA authorization. So this is so important, especially with kids that are out of state, is being able to say, yes, my doctor or my daughter already said that I can talk to doctors, get medical records, find out what's going on. I've seen news broadcasts where a parent has kids that go away to school, and because there are these privacy laws that are in place, they can't actually find out what's going on to their child if something were to happen. And so that's why these documents are so important, to make sure that you'll be able to get that information to find out what was going on if something happened. A few other documents that are important or things to kind of think about is a FERPA release. So you can look at your child's college website and see if they have a FERPA release that's listed there. And that allows you to actually get information from the college as to what's going on with your child. And these are all things that you should get signed before they leave, get them notarized, get them witnessed, whatever's needed, so that you have all of these planning documents in place. I have a checklist for parents when their kids are going away to school that will allow you to get some ideas on some of these documents. So if you want this checklist, either send me a message or comment with your email address so that I can send you the link for that. I will also post it in the comments after the video. Okay, just a couple other things is make sure you have a joint checking account or some way that you can be able to get money to the child, Venmo, PayPal, something to be able to get them money is always a good thing. And then also one thing that I know my mom did not know when I went away to college was knowing your child's roommates at school, knowing their phone numbers in case to get and who to contact in case of emergency. That, you know, if you can't get a hold of your child, you can contact the roommate to find out, you know, what's going on, is everything okay, if you haven't heard from them in a while and you're used to speaking to them. So it's just a good idea to really be able to have that information so that, you know, if you needed to touch base with somebody there, you had somebody else besides just your child. Okay, so if you have any questions on your child going away to college and the planning documents, you can set up a 15-minute consult by phone that we have to go through what are some different options for you. And we actually do have a young adults planning package available for people that want to get that done for their kids before they go away to college, or just if you have an 18-year-old that you want these planning documents for. These are important documents. So just reach out to us. You can always send us an email, info@hermancelaw.com. And you can also visit our website, which is hermancelaw.com. Okay, let's go to the next question. And if you're just joining us, please make sure to post your questions in our comment section so I can try and get to those. Okay, next question. What is your kid's safeguard system? So this is something that's unique to our practice. Since we do focus on families with minor children, this was developed to make sure that parents have plans in place so that their kids are protected. The kid's safeguard system is this here. And what this is meant to do is that, you know, if you were going out on a date with your significant other and you had a babysitter, that babysitter can pick up this document or this folder and get the information in case of emergency to know exactly what to do. So our kid safeguard system is really unique in the stuff that it provides. We do have this separate as a product that we offer to people if they're not ready for maybe a trust or a will package. We do offer this as a separate package to just make sure that you have guardianship stuff done for your kids. And so what the kid safeguard system includes is it includes guardianship nomination. So we do it from both a long-term guardianship perspective to say who you would want if something happened to both you and the other parent in the long term, who you would want to raise your kids. I know it's hard to think about, but it's so important to have this planning done. But who you would want to be guardians as well as short-term guardians. So a lot of people don't think about this, especially if you have guardians, or especially if maybe you are in a place where you don't have any family around. Having short-term guardians nominated would say, you know, these are people that if something happened, these are maybe neighbors or, you know, friends that are close by that can keep our kids in the short term until guardians are able to get to them. And what this does is it prevents the police having to get involved, where they get Child Protective Services involved and potentially have to take the kids out of the home and put them in foster care until family is able to get to them. And so that's what the short-term guardian nomination form does, is it tells law enforcement or Child Protective Services that these are people that we nominate to keep our kids safe until guardians are able to get to them, which I think is really important. Especially if you don't have family close by. And a lot of times we have clients that are maybe transplants to the area and they have no family that live, you know, anywhere, even in their state. And maybe they're, you know, people are on the other side of the country or on the other side of the world, in which case this document allows them to identify people that are close by. We also do letters to all of the guardians saying, hey, you're a potential guardian, there's nothing you need to do, but if you have any questions, to please let us know. included in our Kids Safeguard system is what we call a confidential exclusion letter. And this document basically just says that if there's anybody that you think potentially could petition the court above what your wishes are, to go above and beyond your guardian documentation to fight for guardianship of your kids if something happened. This is a letter that you can write that says, I would never want this person to be guardian of my children, and these are the reasons why. And you can state very specifically why, and use specific examples in there. I've seen them be abusive towards their kids. There's a drug problem. There's an alcohol problem. I don't like the way that they are with their children. They have different beliefs than we do. Whatever it is, you include it in this letter, sign it, date it. We put it in a confidential envelope, only to be opened if this person ever tries to get custody of our kids. But what it does is it puts your wishes in writing, that if this person ever petitioned the court above what your guardian wishes were, it would tell the judge that you wouldn't want them to be guardian, and here's the reasons why. Okay, so it's really just a backup. It's what your wishes are in writing, that if it ever came about. Okay, we also do an emergency contact sheet. So it's basically just saying, like what you would put on the refrigerator that says who the emergency contacts are, information about the kids, where to find a fire extinguisher, where to find a flashlight, all of these really important information that a lot of times people just don't really think to do. If you're just joining us and you have any questions, please make sure to put those in the comments so that I can try and get to those for you. We also do emergency wallet cards, which, if there was an emergency responders would be able to find these on you to know you have minor children that depend on you, and it says who to call in case of an emergency. My husband has this in his wallet, and he lost it at a movie theater, and the movie theater found his wallet with this card, and I was the first person, so they actually called me from this card. So I thought that was kind of funny that it was used in that situation, but I thought it was great that he had that in there. Another really great thing that I love is our car seat stickers that we do. And so if you have children that are maybe can't communicate, they're young, they're toddlers, that if there was an accident, emergency responders would be able to have information about your child to know what their name was, who to call in case of emergency. So that also comes included with it. So that's our Kids Safeguard system. Thank you for asking about that. That does come included with every trust package that we do. And it's just a really great way to make sure that you have this to be able to share with people that watch your kids in case of emergency. They know exactly what to do. Okay, let's get to our next comment, our next question. And if you're just joining us, please make sure to post any question that you have, and I will try to get to that. Okay, next, what is the difference between a will and a trust? This is a great question, and I find probably one of the most confusing concepts of estate planning when it comes to it, where people don't really know what a will or a trust is, and they might have this kind of conception of, oh, I only need a will, or I don't really even need a will or a trust because we don't have that much stuff. So a will is basically a legal document where you state how you want your stuff distributed after you pass away, and if you have minor children, being able to nominate guardians for those minor children. When somebody passes away, a will is filed with the probate court, and it is then made public. And that's when the probate proceeding would start, that says how your stuff is distributed according to your wishes. When you have a will, one of the biggest myths I hear from people is, oh, I have a will, it's going to avoid probate. Well, in California, it doesn't avoid probate. It guarantees probate because it tells the court how you want your stuff distributed. Okay, so it's not avoiding probate, it's just telling the court what to do. In California also, if you don't have a will in place, your stuff is distributed according to intestate law. It's California's way of saying this is how your stuff is distributed to your heirs. A probate proceeding is going to basically give notice to all of your creditors that you've passed away, and if they have any claims for anything, it's opportunity for them to claim anything that any bills or anything that's outstanding. And then the probate proceeding then wraps up by distributing your assets to your estate, to your beneficiaries or your heirs. The probate court proceeding in California, depending on the area, is not a quick process, especially with everything that's going on with COVID. We've had court closures. So general timeframes can take anywhere from 9 months to 2 years. And now with COVID, we're looking at adding an additional 3 to 6 months onto that. So it's a very long process, which means that during this whole time, the stuff in your estate is in your estate. It can't necessarily be distributed. So if you have family members that are depending on this money or part of this estate, they may not be able to access it. The other thing that's really big with probate is it's very expensive. So even if you have a will, your estate still has to pay all of these fees that are associated with probate. And these are statutory fees that are set by California law that says how much money is to be paid in attorney's fees, in personal representative fees, and on top of that, all of the costs. So bond costs, filing fees, appraiser fees, valuations, all of these costs that are associated with it. So it's a very, very expensive process. Even if you think you don't have a large estate, if you own a home, it's still a lot of money that would be paid by the estate to go through probate. Okay, so the difference then is having a trust. So a trust is basically just a legal agreement where you as the grantor or the creator of the trust put specific instructions in writing to the trustee, which is the person who agrees to hold legal title to all of the assets in your trust. And they do this for the benefit of the beneficiaries. So while you are alive with a revocable living trust, you are all three of these roles. You are the grantor, meaning you created it. You are the trustee, meaning you are in complete control over all of the assets in your trust. And you are also the beneficiary. So it's all for your benefit in your trust. You don't lose any control or access to the stuff in your trust. So when you have a revocable living trust, it's revocable, meaning you can make changes to it throughout your lifetime. But what the trust does is it allows you to state, if something happened to you, how would you want your stuff distributed? And because all of these assets that you own are, rather than in your name personally, they're in your name as the trustee of your trust, it avoids the probate process. That's the whole point of having the trust, or one of the big benefits, is that it's avoiding that probate process because the stuff isn't owned by you individually in your name. It's owned by you as the trustee of your trust. So it's owned in the name of your trust, hence avoiding probate, saving on all of those costs associated with probate. So, and if you're just joining us, if you have any questions, please make sure to put those in the comment section. So one of the biggest benefits of having a trust is saving on all of these probate fees. It's also on keeping all of the stuff private because it's in your trust. Trusts are meant to be private. You see it all the time on TMZ when a celebrity passes away. Did they have a will? And then they go over what are the details of the will, because wills are public. But when you have a trust, the stuff inside your trust on how you want your stuff distributed to your kids is going to be private. And so when you have a trust, rather than not having a will and your kids receiving everything when they turn 18, having a trust, you can say, well, I wouldn't want them to receive everything when they turn 18. I would want them to receive it at ages throughout their life, maybe at 25, 30, and 35. So it really gives you that flexibility to create a plan that would really suit your needs for you and your family on how you would want assets distributed. Okay, so that's kind of just a really kind of quick rundown of the difference between a will and a trust. And the ways that a trust can benefit your family. While a lot of times people are very intimidated by trust planning, I think of trust really, they're not just for the wealthy, they're for any family that wants to put a plan in place to protect their family. In addition to that, I think that trust planning is really, it's a normal thing for families to do. And a lot of people don't think of that. It's like, oh, I don't have enough in assets to be able to need a trust. But I will tell you the probably number one client, or the number one kind of family dynamics that we see when we do estate planning, when it comes to revocable living trust, is you have a family, whether they're married or single, where they have kids, whether they're minors or adults, and they own a home, right? They have some money in the bank. They might have a retirement account. They have a life insurance policy. That is the normal, right? That is our number one kind of client scenario of what we have revocable living trust plans for. And our revocable living trust plans aren't just the trust. It includes all of these other planning documents to make sure that you are able to put your wishes in writing so that if something happened, it's legally documented what you would want. So our trust plans include revocable living trust. It includes the will, what we call a pour over will, a power of attorney document, advanced healthcare directive, the financial side, which is the power of attorney. We do HIPAA authorizations, deed transfer, transferring your title from your house, if you own a home, and from your name into the name of your trust. That's why it's so important to make sure you're funding your trust. Okay, I think I have time for one more question. So again, if you have any questions, please make sure to post those in the comments. Okay, so last question. I am recently divorced. What kinds of things should I consider for planning? So such an important question. You know, it's really just kind of thinking about all of the different assets that you have now that you own. Also, beneficiary designations is a really big one that I see for recently divorced people, is making sure that if you have life insurance policy, updating your life insurance policy beneficiary designations with who you actually want listed on there. So if you have kids, if they're adult children, you can list your adult children on there. If you have minor children, you know, that's one of the big things about having a trust, is you can list the trust as a beneficiary, so that if something happened to you, rather than it going to your minor children, which essentially that other parent then would potentially be in control of those proceeds, beneficiary proceeds, you could have a trust listed as the beneficiary, so that your trust would then say how you would want that money distributed for your kids. If you have a power of attorney document, making sure that it's updated with who you would now want. If you wouldn't want your ex-spouse to be there, you know, who would be your emergency contact? Who would be your emergency person to step in for you and to handle kind of this stuff for you? In addition to that is, you know, looking to see, updating any will documentation you have, trust documentation, that maybe if you had a revocable living trust that was a joint trust with your spouse, now creating a separate trust for you that's now your trust with your information, having the backup people or what we call successor trustees listed there for your trust specifically and how you would want them to manage it. So those are just kind of some of the things when you go through a divorce. It's important to make sure that you have that stuff updated. I have seen it in client meetings where there will be a new marriage, and we're going over beneficiary designations for retirement accounts and life insurance, and maybe an account that's really old was never updated with the new spouse. It still has the old spouse, and so that's generally not something great that comes from the meeting. The new spouse is obviously very upset, and especially if they've been, you know, at this point, these people were married for 10 years and they still have the old spouse listed. If anything, it's just a really great exercise to go through and check your beneficiary designations. I am working on a free printable, so if you don't follow me on Instagram, make sure you do, and I'll make sure to get that posted on there, of just going through this exercise of who your beneficiaries are on retirement accounts, checking accounts, life insurance, all of these things, kind of doing this exercise. So lots of free printables. If you can also go to our website and be able to go to the freebies section under resources. We have a ton of free printables there for you to be able to get to download these and just be able to go through these checklists or fill out this information and make sure that you are able to just, you know, kind of just do a quick touch point to see who are listed in certain areas or keeping track of certain things. Okay, that is all that I have time for today. If I wasn't able to get to your question, I apologize, but please make sure to join me again next Wednesday. If you have any estate planning questions that you want answered, I will try to get to those. And if you want to book an appointment, we have a free 15-minute phone call that you can, you know, just kind of figure out what next steps are. What do you need? You can go to our website and book that appointment there, or just call our office, 805-518-9633. and we can get an appointment scheduled for you. So thank you again for joining me today, and have a wonderful day. Thank you.